गूगल शीट्स खोल लें। एम्बेसी मेल्स चेयरमैन करके आ रहा होगा। आया।
Good evening, everyone. Thanks for joining in. We'll be beginning in short 5 minutes. Until then, I will request everyone to kindly switch on your cameras to make this an interactive session. Thank you. A very good evening, everyone. On behalf of BRICS Chamber of Commerce and Industry, I am pleased to welcome you all to this insightful session on Digital Personal Data Protection, or DPDP Act 2023. For those who are new with us, we, or BRICS Chamber of Commerce and Industry, are a non-for-profit organization, non-governmental, representing the interest of entrepreneurs, businesses, and professionals like BRICS nations, which includes Brazil, Russia, India, China, South Africa, and other friendly countries. Our mission is to foster dialogue, enable cooperation, and promote industry best practices across borders. Today's webinar is aimed at unpacking and understanding the compliance obligations and legal implications arising out of DPDP Act 2023. With the digital economy growing exponentially, understanding how to responsibly handle personal data is now very essential. During this session, we will cover various topics such as key definition under the Act, mandatory appointments like consent managers and grievance officers, breach notification requirements, rules for processing data of children and persons with disabilities, employee data exemptions, and penalties which may go up to rupees 250 crores for non-compliance. We today are joined by our two distinguished speakers, Mr. Naveen Kumar, an accomplished IT manager and information security professional with over 20 years of experience, bringing deep expertise in regulatory compliance, ISMS risk, and cybersecurity frameworks. He holds multiple ISO certificates and has supported around 1,200 clients, including those in retail, healthcare, legal, and manufacturing sectors in managing secure and compliant digital ecosystem. We have with us Mr. Gaurav Mahajan, co-founding partner at Percept Law Office, who is a seasoned legal professional with nearly 2 decades of experience. He specializes in complex legal matters, ranging from data privacy and cyber laws to white-collar crimes and AI ethics. Mr. Mahajan regularly appears before the Supreme Court of India and various tribunals and have advised clients across diverse sectors with strategic legal solutions. We warmly welcome you both, Mr. Mahajan and Mr. Kumar, and we look forward to your invaluable insights as we explore the nuance on DPDP Act. Lastly, I thank you all for joining us. Let us now begin with this within time and important discussion on Digital Legal Protection Act. Thank you.
Thank you, Lavanya, and thank you to BRICS. I also thank my co-presenter here, Naveen, to be with us. It's a very interesting topic for all of us, and we have been hearing about it somewhere or the other. And that's the reason we thought that it's pretty good for all the members to understand, all the participants to understand about what the exact actually says. It's a pleasure to be here, and I thank you all for being here. So with continuing with the ambit of what exactly is the law and how it culminated. So very interestingly, it is, if you see it in the screen, it's named as the Digital Personal Data Protection Act. This was passed on 11th of August 2023, and there has been a series of deliberations which led to the passing of this, and that's the reason we want to dive a little into the history and the purpose. So as a landmark judgment from Supreme Court under the judgment title K.S. Puttaswamy versus Union of India, the Supreme Court recognized privacy as a fundamental right under Article 21 of the Constitution. Thereby, the government followed under the recommendation of the Supreme Court to constitute a committee, and under the retired Justice Shri Krishna's committee, B.N. Sai Krishna's committee, this entire exercise was carried out, wherein a lot of drafts of this law was shared and updated from time to time. Eventually, after sharing number of drafts for public consultations, eventually on 2023, 11th of August 2023, the law was passed. There has been a series of recommendation by the parliamentary committee as well before the passing of the law in the previous draft of 18/19/2022. But eventually we have this duly published and approved by the parliament as well as published in the official gazette. It's very important to understand what is the purpose behind this law. Basically, the purpose of this act is it provides for the processing of digital personal data in a manner that it recognizes the right of a personal data as well as the individual to protect their personal data. Also, it all revolves around how do we process the data, the personal data, and the processing should be done for lawful purposes and matters connected thereto or incidental thereto. Now, very important is certain definitions under this law. What exactly do we mean by personal data? So it has a very wider definition which covers a lot of perspective. It says that any data by which an individual can be identified. So it could be your Aadhaar card, your phone numbers, your PAN card, your fingerprints, your entire biometrics, facial recognition, your email IDs, even your gender. So these are the attributes by which an individual can be identified, could be located to, and that's the reason it has a very broader definition under the personal data. Now, very importantly, we have certain terms which could be new to you, but we'll try to explain it to you and what are the meanings thereof. Next term we have is data principal, which means that an individual to whom the personal data relates to, or in case of a child or person with disability, will include his parents or lawful guardians. So data principal plays a very important role as far as the other participant in terms of definitions. So is a person to whom the data relates to, very importantly. Then we have the definition of persons. Persons basically would include everything under this definition, because it says that includes individual, HUF, company, firm, association of person, body of individuals, whether incorporated or not. It also includes state or any other artificial juristic person. So anything which is referred as persons under this law will definitely cover all the entities as what we have just now read and understood. So very importantly, it applies to everybody. There has been a confusion across, because I've been taking these sessions for over last 3.5 years now. I've taken more than 150 plus sessions for various organizations. There is always a confusion that it doesn't apply to us. We are individual, we are a proprietorship concern, partnership concern. Why would it apply to us? We are a society. Why would this apply to us? No, it will apply if you are collecting personal data in a form which is recognized under the law that we'll discuss. Then this law will definitely apply to you. Now we have a very important definition called data fiduciary. Data fiduciary means any person who alone or in conjunction with other person decides or determines the purpose and means of processing of personal data. So ideally, data fiduciary very broadly would construe anybody who's collecting the data for providing any goods or services to individuals or to the consumers, the customers, etc. But this is not the only exception. There is a whole lot of exceptions that we'll discuss subsequently. Next is the importance of understanding what exactly is processing means. Because ideally processing, we have been talking about it in the previous slide, that it relates to the processing of digital personal data for lawful purposes, which are very common and transparent elements of data privacy legislation all across the globe. Now, processing is a very wider terms in terms of activities, because it relates to the processing of personal data, either partly or semi-automated operations, or operations which are performed on digital personal data in a way that includes collection, recording, organization, structuring, storage, adaptation, alteration, retrieval, use, alignment and combination, indexing, sharing, disclosure by transmission, dissemination, or making available the data, or restriction or destruction of data. Those are all activities that would be performed on personal data. Now, the next definition that we have is consent manager. Now, very importantly, this is very unique to the Indian law, unlike what we have seen in other global legislation. There's a UK GDPR, CCPA, also the PDPA legislation, or any other legislation within the UAE countries, or Japanese data protection law, or Australian data protection law. So this is a person, this is an entity, I would say. A person, because person would include the definitions as mentioned above, would be required to be registered with the Data Protection Board, which ideally would be the governing body taking care of any issues related to arising thereto under the data protection law, which is the DPDP Act. And with regard to the registration, there are certain rules that came up very recently. Those are the proposed rules, or the rules for discussions for public consultation on 3rd of January 2023. whereby it suggested that this would be more of an entity which should be independent from the data fiduciary, because the consent manager would have the responsibility of managing, reviewing, and withdrawal of the consent, which would be exercised by data principals through the platform of data consent managers. So ideally, consent managers registration qualifies on certain technical terms, operational terms, and financial terms. Financial term, all those prescribed rules were shared in the public domain, though those rules are not yet final. We had also made our submissions to the rules in terms of our objections. Very importantly, this though act has been notified in the official gazette, but its implementation and a final approval with regard to the notification for making it applicable across is yet to be done, including the rules. So, but it's very important to prepare in advance, because despite the window of the timelines which the organization will be given to implement this law, it's very important to prepare in advance, and readiness mechanism is something which we are helping the organizations to implement. So very importantly, consent manager is a person who would be registered by the board, subject to technical, operation, financial conditions as may be prescribed. He will be a single sole point of contact to enable data principals to give, manage, review, and consent, including withdrawal of the consent, through a very important factor, through an accessible, transparent, and interoperable platform. So this gives the connotation that these platforms will be platforms which could be easily exercised by data fiduciary, data principal, and these could be e-platforms or electronic platforms or digital platforms. Another very important definition is data processor, means any person who processes the personal data on behalf of data fiduciary. There would be so many circumstances where data fiduciary is only collecting the data and storing the data, but is actually not processing the data. Or even if they are processing the data, they hire third-party services for offerings related services to their customers, to vendors, suppliers, etc. On all those activities, wherever the data is externally processed by beyond the data fiduciary, data processes come into picture. Now, very importantly, wherever we have systems or mechanisms of implementing and protecting data, breaches are bound to happen. I mean, we deploy the best mechanism, but breaches are bound to happen. We can mitigate them. So what exactly is personal data breach? Let us understand. It says any unauthorized processing of personal data or accidental disclosure, acquisition, sharing, use, alteration, destruction, loss to access to personal data that compromises with the confidentiality, integrity, or availability of the personal data. So very importantly, these activities are also very, very widely structured. You would see that our Indian law, which is the DPDP Act, is somehow very much influenced from GDPR, which is another very reputed global privacy law. So we will find some kind of a correlation between both of them, but we have our uniqueness in terms of the Indian law. Now, very important factor is the applicability. How does it apply? To whom does it apply? Where will it apply? And what circumstances? So ideally, the processing of the personal data is something which is a core essence. And it says that wherever the data is collected within the territories of India, when the data is collected in digital form, yes, very importantly, data should be in digital form. It should not be in physical form. But importantly, if you are converting a non-physical data or a non-digital data into a digital data subsequently, on that digitalized data, the law will equally apply. So anything which is available either in digital form or converted into digital form. Very importantly, it also applies to activities where the processing of personal data is done outside India. Yes, very importantly, any data which is processed outside India in connection with activities of offering goods and services to data principals within the territory of India. We have number of platform businesses where their cloud storages, the processing of data happens outside India, whereas they're offering goods and services through their apps and platform in India. So anything which is carried out outside India for the purpose of processing of data outside India, while these services are being offered or goods are being sold in India, the law will apply. Also, very importantly, the law has element of transfer of data outside India, because in this global world, we are all processing and sharing data outside India, and we are exchanging data in a very rapid manner. globally. So cross-border data transfer is something which gets covered under this. It says that the central government would restrict certain transfer of personal data by data fiduciaries to such territories or countries as may be notified. So there will be a clarity on this when the government, central government specify the territories which are restricted where the data could not be transferred. But as of now, it's more of a very exclusive definition where it applies the transfer of data to all geographies unless notified by the government. Now, very importantly, on what situations the law will not apply. So very importantly, very basic factors where the law will not apply. For example, if we are processing the data for our personal use, for our domestic purposes, for our own purpose, for our own use, where we are making the data publicly available by ourselves. Like for example, if we are maintaining food blogs, so we have people who are enthusiastic food bloggers, travel bloggers, Instagram post, all those Facebook posts, everything that is posted by ourselves on our own is something that the law will not directly apply, but the responsibility of storing and securing the data will definitely apply on data fiduciaries. Now, any activity by which the personal data is required to be made publicly available for application of under any kind of law or any requirement, like for example, if email IDs, house numbers, addresses, PAN numbers are published by central government while offering a lot of schemes and to notify the applicable candidates or the people who are qualified for a particular scheme or examination, etc. There in that scenarios, these obligations, these are one of the examples that the publication of personal data in that sense, the law will not apply directly. Yes. Now we'll go to a very important factor of how it has to be implemented. How does it work? For example, if the law is made applicable tomorrow, what all exercises to be done by organizations? When I say organization, it includes everything. Proprietorship concerns, individuals, partnership concerns, organizations, NGOs, societies, etc., whatever you can construe of. So ideally, whenever any information is requested to be collected from a data principal by a fiduciary, there is an obligation to inform through a notice, a valid notice. And this has to be required before taking the consent or while taking the consent. Very importantly, the laws also apply in situations where the data has already been collected before the commencement of this law. So if at all you have collected in the past on those activities also, this law will apply, and you will have to issue a notice saying that what all you collected in the past and what all you have done with the data. So ideally, the format of the notice has not been prescribed as of now. The government has left it open to everybody to interpret as per their own formats because of the regulatory requirements and regulatory sectors. But essentially, what all has to be mentioned is mentioned herein. It means that in the notice, the personal data which you collect, the purpose for the personal data for which you want to collect or you have already collected it, that will be mentioned. The manner in which the right of withdrawal of consent through a link of a website or an app through a communication link has to be mentioned, including the mechanism where the data principal can exercise the right with regard to seeking redressal of their grievances. Also, the manner of making complaints to Data Protection Board, all these elements has to be specifically notified. Now, very importantly, globally, this has been a great debate that, a lot of times the people who are collecting the data, or the persons who are collecting the data keep the notices very vague. It should not be like this because globally, a lot of legislations and a lot of legislation, number of orders have come, number of judicial pronouncements have come, which says that you need to be very, very specific to what data you collect, for what purposes, and if you are sharing the data with any third party, that also you need to specify to whom third parties you're sharing it, for what purposes. Everything has to be transparent and crystal clear. Now, very importantly, is another challenge which we have been talking about with our colleagues or the industry on a random and larger basis, is the requirement to give this notice in 22 languages. If usually we communicate in English, we send emails in English, we communicate with customers in English. But if the customer says to you and replies back to you, sorry, I can't understand English, I want to understand the notice in my vernacular language, my local language, which if it's fallen within the 22 languages of the as specified in the 8th schedule of the Constitution, then you need to put up some kind of element where he can, see the translated version of that notice. So ideally, through use of technology, all these processes can be very much simplified. Now, another very important part of the entire process is, once we have discussed notice, next part is consent. It's more of a flip side of the same coin, because it works in both the ways. Notice coupled with consent formulates a proper procedure. So under consent also, it's an obligation on data fiduciaries to take consent from data principals, and it should be free, specific, duly informed. It should be unconditional and unambiguous, with a clear affirmative action of what exactly you're taking consent of and what exactly data you will be processing. Very importantly is that the consent in this mechanism will constitute as an agreement, which would give the right to data fiduciary to process the personal data on behalf of the data principal. Also, as a right of withdrawal of consent that we discussed will be exercised through consent manager, and every request for consent, again, the language factor will come into place. We'll take you to the next slide, which is very important, because under this slide, you will understand certain legitimate uses where the exceptions will come into picture and fall. So ideally, these are the circumstances where the requirement to specifically take consent is not required under these circumstances. But ideally, still a notice requirement is something that would still has not been excluded or has not been allowed. That notice should be given. Only the consent is not specifically taken. Ideally, these are the functions and the requirements where it says that consent is not required, which are very relevant also. But as far as the corporate bodies are concerned or industries are concerned, very important, I read the third last line point, which talks about that it is not required to take specific consent for employment purposes, for safeguarding employee from any loss or liability, as far as confidentiality of secrets, IP, intellectual property is concerned, prevention of any kind of corporate espionage, or any service and benefits sought by the employees. Now, we have very widely made this understood to everybody that every organization hires employees, right? So is it required for every organization to take a separate consent from an employee? No, not essential, but it's also very important to inform the clients that what all data you are collecting, for what all purposes you are collecting the data, and for what all purposes you will be sharing the data outside the organization with third parties. Like, for example, a lot of organizations provide medical insurance to their employees. It is something that in those necessity, you have to share the data outside to the company who offers those kind of services for health insurance or medical insurance, etc. Similarly, there are a lot of gym memberships and other kind of activities which are used. Sometimes you go for offsites, you share the data with your travel agents for the purpose of booking the flights and hotel rooms, etc. So there could be number of activities which would form under the category of employment purposes, right from your processing of your PF, gratuity, other benefits, made statutory benefits or other benefits. So on those requirements, but you need to equally wisely amend your employment contracts to adjust the requirement of data protection, and also on a group level inform the employees how they are collecting data and in what manner their data will be processed. Now, these are the very important journal obligations of a data fiduciary, because every data fiduciary has a requirement and in terms of the obligation to deal with the data, and for what all obligations are there, we'll go through it. So ideally, the point number 1 and 2 is something that we have discussed, that data should be processed for lawful purposes. There should be a proper mechanism of taking consent, giving notice, describing clearly with regard to the personal data sought to be collected and processed and to be shared. Also, there are very important requirements and responsibility of complying with the other provision of this law, including, very importantly, where my colleague and friend Naveen will come into picture, is point number 4, 5, 6. including 7, is that implement appropriate technical organizational measures for compliance with the provision of this act, take reasonable security safeguards to prevent personal data breach, notify the board and affected data principal in the event of personal data breach, must remove personal data after it is reasonably assumed that the purpose for the personal data retained is no longer required or it's not solving any kind of purpose or is not necessary. Now, very importantly, all these activities now run down to the factor of any organization having a complete data protection policy, privacy policy, data protection structure, incident management reporting and structure. All these policies should be in place. As far as the rules are concerned, the rules have specified that remedial action has to be taken and that has to be submitted to the board. These requirements are published in the proposed rules. The 72 hours window has been given for remedial actions, but as there is no specific timelines as such whereby you need to report to the data protection board as an effect. It says that so all this documentation structuring something which is very much important. 7th point also relates to the requirement of data retention. Data retention is one of the most important parts. So here point number 7 comes into play, because you would be exercising certain businesses in a regulated sector like insurance, banking, finance, telecom, where you have parallel requirements to maintain data and to keep the data for a number of years. So this clause will not come into in contradiction with that. This will only go hand in hand with regard to that requirement. Also, there is a need to publish the information of a data protection officer or any person who can answer to the query of data principal. We already have under the IT Act a grievance officer under the privacy policy, but with regard to the data, these mechanisms have to be adopted. Also, there should be proper mechanism within the organization for the redressal of the grievance of a data principal with regard to the data they have given it to you. Also, when you are offering any kind of goods or services, and for doing that you engage, involve, or appoint any data processor, a third party, all of the exercises should be done under VET, and that's why the data sharing and data transfer agreement or processor obligation on data processor. For example, if you are a data fiduciary, you hire for the purpose of protections. At the end of data processor, you will be liable because data processor is not liable directly. So you need to do very the structure in a way that those responsibility doesn't fall onto you, and data processors are equally importantly, but because it talks about the process of data of child person with disability. This is very important because most of the organization would be running schools, kindergarten schools, higher schools. You qualify above 18 years, you're no more a child. You become adult. But then most of times there would be students who will be taking admissions below the age of 18. Then on those responsibility, how do you safeguard the data? What all you need to do in that scenario? You need to take specific, informed, and structured consents from their parents. So all the admission forms, all the exercises that to be done during the running of a school, organization, colleges, coaching centers, courses, etc. You need to structure those documentation properly so that you cover the element of protection which is required. And this is a very sensitive area because it's not only about college, it's also about e-commerce platform where you invite a lot of youngsters to come and log in and create their accounts and use their websites, etc. So ideally, we are datally so much covered that the sensitivity around the use of child's information, photographs, attributes, it's completely important. And under this legislation, there is a specific bar from advertising in a way that reaches and touches the attributes of a child, or where it should not be, the advertisement should not be targeted directly to children in terms of affecting their innocence. So these are very, very stronger factors that have been covered. Now, very importantly, we'll come to the next point, which is the additional obligations of a significant data fiduciary. So you would be equally curious to know that, why suddenly, what is this additional definition? What is this additional obligation? We were talking about data fiduciary. Who exactly is significant data fiduciary? Yes, this is a more qualified class amongst the data fiduciary, which has been termed as significant data fiduciary. And there are certain factors that qualifies you to be a significant data fiduciary, because the obligations are much more stricter. So ideally, if you're collecting data in voluminous sense, the nature of the data is sensitive, there is an amount to risk to the personal data of a data principal, or there could be a potential impact on the sovereignty integrity of India, or risk to electoral democracy, security of state order, and various other. I think there would be more qualification that will be specified under the rules in terms of who will qualify as a data fiduciary. But anybody who's collecting data in huge form, or there is a sensitivity around the collection of data and the personal data, this law will definitely apply. And for SDF, in short form, we call them significant data fiduciaries. There is a huge amount of requirement to appoint. There is a mandatory requirement to appoint a DPO, which is a data protection officer. And DPO would be a person who would look into the issues related to the grievances of the data principles. And very importantly, it will be individual. A DPO will be individual who will be responsible to the directly to the board of directors or any similar governing authorities of SDF, because this is a very sensitive issue, and the board should be equally made aware of all of this. That's the reason there is an obligation to report to the board directly. And also there is an important requirement to appoint independent data auditors to carry out data audits, very importantly. Now, under the proposed rule, it says that as soon as the act is made applicable, within 12 months, you have to carry out data impact assessments, as well as appoint a data auditor who will carry out the following activities, which is the periodical data protection impact assessment to assess and manage risk to the rights of data principals, and also take necessary steps which may be required for the protection of the personal data. So there is a huge amount of obligation on DPOs and for carrying out these audits, and also appointing independent data auditors. Now, there are also very important factors that need to be understood with regard to the rights of a data principal, most of whom which we have already discussed, and there are certain duties also. Now, very importantly, from a data fiduciary, the data principal has the right to seek information, how the data has been processed, what has been processed, how it has been processed, to whom the data has been shared. All those details a data principal can ask you. So don't mind you receiving number of emails from your customers that how you have to handle our data. Please give us a disclosure. Please tell us extensively, very clearly what you have done. Also, they have a right to correct the data and to seek the remedy of erasing the data if required, updating the data, completing the incomplete data, correct the wrong data or misleading data. Also, you need to give them a right to access their redressal of the grievances by appointing a data protection officer or any other suitable person, including the remedy to give them the privilege to reach to the data protection board. Very uniquely, we have a right to nominate. This is very unique to the Indian law only, not unlike prevalent to other data privacy laws across the globe. It's the right to nominate. The person, the data principal, can nominate somebody in case of, and those person who will be nominated as a nominee can exercise the rights of on behalf of data principals in case of a death of a data principal, or in kind of incapacity of a data principal. So nominee will come into picture and play a very important role as well. Now, very importantly is the duties of data principals. So they can't have all the rights. They're also equal balance between their rights and duties. So ideally, the data principal shall comply with all the applicable laws and should not be in breach of any law as far as giving the data or requesting for processing of the data, or etc. activities. They should not impersonate anyone. They should not file false grievances or complaint before the data fiduciary or the board. They should not suppress material information about the personal data, in terms of the documentation which is given in terms of unique identifier, proof of identity as issued by the state. Now, most importantly, they should also not furnish unauthentic data. They should always furnish authentic, variably authentic data as far as whenever they are seeking their right to correction and erosion. Now, these are certain factors where exception works into place. Most of the factors absolve the liability of obligation with regard to the data fiduciary and the rights of the data principal, or in fact the transfer of data outside India. Most of the element you will see runs around the administrative activities of the government or judiciary, etc. But there are also certain important factors that we have highlighted in the middle, that irrespective the obligations may sound little obsolete in these activities, but there is always and always a responsibility on everybody to protect the data in their possession, in their control, by taking reasonable security safeguards to prevent any kind of personal data breach. Even the government or any entity which comes within the meaning of state will not be spared as far as the obligations is concerned. Now, there would be a body that we discussed initially in terms of which will regulate the process of taking complaints from data principals. These are the factors. We'll go to the last slide, which is the most important slide of the penalties and the mechanism how penalties can be imposed. Now, the board doesn't have a blanket power to impose a huge amount of penalties directly of 250 crores, 200 crores, 150 crores. There are certain factors that need to be determined, and those are very important factors, according to me, to create a balance and a harmony. So ideally, in case of any complaint or in case of deciding any monetary penalty, the board will take into consideration the nature and the gravity and the duration of the non-compliances, the type and the nature of the data affected by the non-compliances, the repeated nature of the non-compliances by a data fiduciary, penalties will go higher. Whether the person, as a result of non-compliance, has realized any gain or avoided any kind of losses. Important part is that what are the mitigating steps the person took in terms of the consequences of the non-compliance and the timelines and the effective note of the non-compliance and the remedial actions that they have taken. Also, very importantly, is that whether the penalty, monetary penalty that will be imposed should be appropriate, should be proportionate and effective, considering the element of securing the compliance factor rather than deterring to imposing penalties. Ideally, those permutations should be taken into consideration. The last point is very important. A likely impact on imposition of monetary penalty on a person. Like, for example, we are the nations of startups, right? If the entire worth of a startup is about 50 crores, 25 crores, or 5 crores in that sense, the board cannot go and impose penalty to the extent of 200 crores or 250 crores. So they will have to take into consideration the kind of impact that will be imposed, that will affect the person means the data fiduciary, and what could be the implications. Now, understand the factors that could lead to the penalty, if at all. We'll discuss that. The failure of data fiduciary to take reasonable security safeguards to prevent personal data breach, the penalty is maximum 250 crores. Failure to notify the board or affected person in case or in the event of a personal data breach, or non-fulfillment of additional obligation in relation to children, child, or person with disability, the maximum is 200 crores. Non-fulfillment of additional obligations of significant data fiduciaries is maximum 150 crores. There's also a penalty mechanism on data principals. If they fail to comply with the duties, this amount is very less though, but then as a deterrent mechanism, they are also penalized. The maximum is 10,000. And for non-compliance of any of the provision under this act, the maximum is 50 crores. So ideally, the factors of penalty has made this entire legislation a very, very stricter obligations in terms of implementation. And there is also a sense of creating an atmosphere where we secure ourselves, we secure data, we understand the importance of data. We also understand the importance of what all data we should collect, and should also minimize collection of the data randomly. And believe you me, we all are victims of those hoax calls that we receive. They know where we are living. They know what kind of food we are eating. They know what kind of house we are intend to buy. While these people randomly gets a phone number numbers where we stay, and they call you through all these marketing calls. So I think all of those nuisance should be controlled, or ideally look forward to those scenarios where these activities get controlled. Now I will like to give the stage to my colleague Naveen, who is an expert in the cyber element. I, while advise on the regulatory policy and the documentation implementation side and the legal side, Naveen helps us in terms of implementing it in terms of technology. Naveen, over to you. Thank you.
Thank you, Gaurav. I think nothing is left for me. You have covered each and every point of DPDP Act. So everything I think pretty much clear for everyone, I hope. So in terms of technology side, yes, you have already discussed about the data security, data governance, consent management, everything you have already covered. So I will not talk about the tools and applications here. Few of the things are like, if we are talking about the data security, how we can secure the data. So data encryption is one of the method. Access control is should be implemented. Endpoint security should be there. Regular patching of the systems and server softwares. So these are the few practices which we need to implement in our environment for the data security. And when we are talking about the governance part, so we should have a clear maintained inventory of personal data, what is collected, why, where it is stored, and who are the person who can access it. So everything should be managed. I mean, in terms of who has the access of that personal data. So that kind of data inventory system should be implemented. Data classification should be there. Classification means you can classify the data, which data is very sensitive and which data is non-sensitive. So that is why that is what you can implement in your environment for the data classification system. And as you talked about the data minimization, so data minimization is one of the thing, but one of the key thing actually when we do any data collections. So why we are doing that data collection, and if any data is not required for us, we should not collect that data. So that is why data minimization comes into the picture, because if you are collecting the data and there isn't any use of the data, but still the data is giving the identification of a human, a person, or of an individual. So I think that data is important. So if that is not needed, we should do the data minimization. Consent management, yes, consent management is taken care by the consent manager itself, but there are a few tools available in the market through which you can build and integrate the consent management system, because collect, record, and manage consent from the data principles. That is the key agenda of the consent management. Allow easy withdrawal of consent. Easy withdrawal of consent, when I'm saying easy withdrawal of consent, it means uh, a data principal should be able to understand uh, what kind of consent company is seeking for from a data principal. So that should be implemented on your application or any portal which you are giving upfront to the data principal for filling the details and to collect the data, right? So you will have to create in a way that should be language friendly as well, because language is in our India there are multiple languages. So let's suppose you are collecting the data, but any person who is not able to read the consent form which you have implemented on your application. So in English, any person is filling the name, email ID, and phone number. These are the things anyone can write on the application. But the consent which you have asked from the data principal, that should be available with his or her language itself, to understand what kind of consent you are asking from the data principal. Right. So now coming to the data breach management. Yes, data breach management is also one of the factor where you need to implement the SIM solution, IDS, IPS solutions, incident response. I mean, you need to prepare incident response plan where you need to record each and every section of the incident, and you need to be ready with the chronology of any incident notification system where you can report the breaches and data protection board and affected individuals. So these kind of mechanism are very much required in DPDP Act data breach management. And when you're and I think one of the key factor is also training part. So
Yes, very important.
employee training is very much required, not only for your employee, and your vendor should also comply. Your vendors should also comply within this DPDP Act. When I'm saying vendor, assess vendor compliance with DPDPA, according to the DPDPA, execute data processes agreement with them, monitor data handling practices of third parties via regular audits and risk assessments. Right. So these are the things which any entity need to follow for their vendors and third parties. And I was talking about the training and awareness. So I'm sorry, I deviated the part to the vendor. The training and awareness part I was talking about. So training is something which you need to drill down for each and every employee, right? Train system administrator, developers, support staffs, and data protection principles, conduct simulations and drills for breach and grievance handlings. Like these kind of practices, any entity need to follow to make everyone aware about the DPDP Act. Right? So these are the things. So I'm not talking about the tools and applications here, but yes, a few of the things I have already told you that data breach management, which is very much required. SIM solution, I have already discussed about it. So if anyone want to discuss more about the technology, what are the tools are needed, and how we can create this kind of mechanism, the mechanism which I have discussed here. So on those parts, we will definitely help you out on the according to the on the policy sections and the structure and framework. Gaurav is here to help you guys. But all the mechanism from the technology point of view, I have already covered. I think mostly part I have covered. One of the part is also data subject rights. So there should be a kind of a automation, allow individuals to view, update, and delete their data. So that is not required in each and every case. Let's suppose uh, data principal should not have rights to delete their data from the banking application, right? You have taken the consent, though you have captured each and everything, and there is no. I mean, it varies business to business. So if any telecom companies you are giving details to a telecom company, and now you are saying no, delete my data, but there are as Gaurav mentioned, so as per the government obligations you need to retain the data and maintain the data up to so and so years or so time. So you need to do that. So in those cases data principals cannot delete the data, right? But if you are running a kind of an application, let's suppose a loan application you are running individually, or e-commerce platform, you are registered with the e-commerce platform. Now I don't want to use that e-commerce platform and I want to delete my data from there. So that kind of mechanism, I mean data subject rights automation should be implemented. Facilitate data probability request, handle grievance redressal within stipulated timelines. So these are the things which needs to be implemented as in data subject rights automation.
And as Naveen rightly pointed out, these factors, I mean, it is a complete ecosystem that will be required to be created. It's not only about policies and documentation and structuring. It's also about creating that ecosystem where the safety of data should be given utmost importance, including, as Naveen mentioned, also ensuring that the vendors you would be listed with are equally certified, so that your risk in terms of breaches get minimized. Yes.
Yeah.
Any questions if anybody has, we'll love to take the questions. Otherwise, we'll close the session and thank you all.
Any questions from anyone?
In any case, Lavanya and to the entire team of BRICS, we can be reached out in case of any questions that you may have. My email ID is available with all of them. My contact details are available with all of them. And it will be great to listen to your queries and answer to your queries as well. Thank you, everyone. Thanks a lot for this opportunity and
Thank you,
your
Lavanya.
time.
Thank you, Gaurav.
Thank you so
Thank you,
much,
BRICS
Mr.
team.
Gaurav. Thank you, Mr. Naveen, for providing your time today.
Thank you. Thank you, Gaurav ji and Naveen ji.
Thank you.
Whatever questions will be there, we'll be writing to you or asking you in person. And thanks for the amazing session. We look forward to have more such kind of sessions with you.
So, thank you.
Thank you so much.
Thank you.